I put everybody in a room. I begin to talk about concepts of law, and then I will randomly point to someone in the audience and say, do you think that's right? Do you think that's wrong? What do you think should happen in this situation? And then I, much like a law professor, tell you why you're wrong. In these new times, we can't do that. So in these new times, what we're going to give you is a basic overview of law as it stands. Now, a disclaimer. This is not legal advice. This is an educational and informational discussion of the current state of law and the reason for that law being that way within the United States. There is no one book of law. Every state's law is different. Every municipality's codes are different. How a federal law that applies nationwide is interpreted in different states will vary based on the holdings of those circuit court. That's going to be something we cover very quickly in the first part. So the takeaway is this is not legal advice. It is educational and hopefully entertaining information to give you. Legal advice is something you get from an attorney, that you have gone into their office and met with them, paid them a retainer of their choosing. Nobody PayPal me $1 and say I've been retained, and they have agreed to represent you. This is not that. I have to be very clear. There are ethical boundaries that I cannot cross. One of them being making it very clear, I am not your lawyer. Please do not take things you hear today, go out, burn down a house or something, and say, but a badger on the internet said it would be okay. A, will not hold up well in court. B, I will not acknowledge that I ever talked to you. So, that said, let me explain just a little bit about how the United States and its laws got to the current portion. Current portion, it's the small size of it. The current situation of the law. When we formed the United States of America, we adopted in full the common law that was in existence at the time of formation, with some exceptions, unless we had otherwise modified it. Now, there was a court case that determined that we had actually adopted the common law of England. And what is the common law? To explain that, you have to understand what is law. What is the law? The law is many things, but for the purpose, the law is many things, but it's definitely not justice. But to explain that, let's break down. There are really, for our purposes, two types of law. There is statutory law and there's common law. Statutory law is the stuff that is written down in books. All right, it's the ones the really smart people used to write down, and everybody voted on, said aye, and it became the law, and now you're beholden to it. And then there is the common law. The common law is the law that has evolved almost by tradition. It has evolved from the cases of merry old England and cases since then. The common law will cover things such as property, such as contracts. It will cover things such as some probate and will matters. It covers legal concepts and defenses. It did, for a period of time, cover criminal offenses as well, which was a horrible system, and we'll get into that in a minute. But the important part of that is to realize that the common law is a created law by tradition. A judge in the 1500s said, well, we're going to require that certain documents, certain contracts must be in writing. They cannot be proven orally by what we call parole evidence. And then another judge a few years later referenced that case and said, okay, we're going to keep that holding. And then another judge referenced that case and said, okay, we're going to keep that holding. And then another judge referenced that case and said, okay, we're going to keep that holding. And that became a common law rule. We actually call it the statute of frauds. It's a real thing. Certain types of contracts must be in writing to be enforceable unless exceptions apply. That's how the common law develops. It's basically a created and agreed upon sense of law by the judges. Now, that is completely different from the statutory law, which is a bunch of people made a law. They wrote down a law. It is a law. It is in a book of law, and that's how it works. So the common law is a commonly changing creature of jurisprudence. Fancy word for Judge Dundid said. The statutory law changes by legislation. Those are things Congress writes, your state representative writes, all that writes. And even in the common law, even the things that are generally accepted, it's not applied the same. Courts in different jurisdictions interpret it different ways. So a common law rule where I am located in my wonderful basement in Pennsylvania is going to be very different from the common law in, say, Arizona or California. We have majority rules. We have minority rules, which is not saying there's one justice system for people who are not white. That's just a fact, and we're aware of that. We've been working on it. We're making progress. I promise you, we're making progress. If somebody would just get Lindsey fucking Graham and Mitch McConnell out of office. I'm not going to go political. But anyways, the majority rule is where a number of jurisdictions all say, this is the way we are interpreting. Okay, so there's 50 states in the United States of America. If 26 of those states all interpret a piece of law, legislation, or common law concept in a similar or same manner, we call that the majority rule. It is the rule that the majority of courts have adopted. Therefore, it is the rule that is the majority rule. The minority rule is the other end of that. If of those 50 states, 24 adopt the other way and hold differently, that is the minority rule. I go into all this because I want to make it really, really clear. Nothing I say here is legal advice. Plus, it helps to have a basic understanding of why we have some of the weird-ass shit we have in our legal books. Anyways, Basic Law for Dipshits is it's a panel that is intended to give you an idea, not of how to handle matters on your own, although with enough research you certainly can, but to explain to you why in the vast majority of cases it is not a good idea to try to handle these matters on your own, and to allow you to be armed with at least a single shot BB gun against the purviews of the legal system should the eye of Sauron ever fall upon you. To that end, we're going to open with what I call sexy law. Sexy law is the criminal law. It's the criminal code. That is Law and Order. That is NYPD Blue. That is Zootopia. Everybody loves criminal law because they've never been on the wrong side of it. The criminal code is sexy. People like it. All right. And by and large, what you must understand about the criminal code is while it was once a creature of the common law, it no longer is a creature of the common. I cannot think of many, if any, jurisdictions within the United States that still rely upon common law crimes. Most of these states have adopted in some manner something called the Model Penal Code, which was put together by the American Law Institute, which is a group of very big-brained attorneys and judges that would sit down and they write model and uniform proposed codes that they then submit to legislatures, and legislatures then argue about it and modify them slightly, but by and large pass them. Almost every jurisdiction has adopted in some manner a statutory criminal code. Now, that goes back to a general idea that you cannot punish someone without at least notifying them they cannot engage in an activity. There's a very nice Latin phrase for it that I can't think of off the top of my head. But what it means is if there's not a law against it, you can't punish someone for doing it. Somebody on my next door is looking to get auto body and paint work done on their Harley. Just thought you may want to know that. So that's why you go into these codes and you look at it, and there's good reason for that. The common law, when it came down to criminal codes, it was insane. It really was. It was bad. Okay. Let me give you an example. The common law crime of rape. I'm just going to bring it up, and I'm reading it. I'm going to read the definition to you directly. The common law definition of rape was more or less forcible compulsion that inflicts serious injury and against a woman. It was vaginal penetration. It was by forcible compulsion. That means you had to use force against another person's will. Now, you may not see the problems. That's because you're not a lawyer. Please allow me to explain what the problems were. One, under that law, under the common law definition, you couldn't rape a man. It had to be a woman. You could only rape them by penetration of one area. There was por anus and por os, and that was by mouth or by ass. And those would not qualify. Those would have fallen under sodomy. It had to be forcible. You had to use physical force. Not just that, but physical force. You can see why it may not have caught things we wanted to catch, and that's why we don't do a lot of common law crimes. As for most of you out there, though, the fact of the matter is you're not going to have an issue where you're going to be dealing with criminal matters. A lot of you are never going to show up in criminal court. It is, by and large, the rarer part of law, and people will ask why I spend so much time on it, and the fact is that's what you all want to hear about a lot of the time. So I will very briefly go over a few aspects of criminal law you do need to be aware of in case you are ever stopped. One, you have what are called Miranda rights. The Miranda rights are rights given to you by a case called Arizona v. Miranda. The idea of these Miranda rights, and we've all heard them. Everybody hears these rights on TV. You cannot be forced to speak against yourself. You have a right to remain silent. If you choose to not assert your right to remain silent, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. You know them, right? Believe it or not, the police, did not used to have to give you that warning at all. It was assumed everybody knew their rights. There was a case out there, and I want to get the heading right on this. If you see me going over to the side here, it's because I have notes. It doesn't seem like it, but I do have notes about like high points. But then I'm like, that one case, Ghost House. One of my cases on here is just listed as Ghost House. I don't remember the facts and holding of whatever case I referred to as Ghost House. I normally have notes. But yes, your Miranda rights, You would think they would do it. Miranda v. Arizona. In that case, what the Supreme Court ended up holding was we can't just assume people know about these rights. And in certain situations, these rights have to be explicitly told to somebody. We have to say, you have these rights. Okay? Now, when do the police have to, and this is a question for the chat. I'm watching the chat. I've got the Telegram chat open over here on the left. If I'm looking over here, but I want to ask you, when do the police have to provide you with your Miranda rights? When do they have to make you aware that you have the right to remain silent? You have the right to an attorney. When do they have to tell you that under the case holdings that have come down from Miranda v. Arizona? I see when they want to question you. Do I have anybody else? Do I have any other suggestions? Carmen Miranda writes, no. Where in the world is Carmen Miranda? When you're being detained. No. On arrest, not detention. No. To give you, when it becomes clear you are in custody, no. When do they have to give you these? The Miranda rights must be provided to you prior to a custodial interrogation. Okay. When they put the handcuffs on you, they do not have to read you your Miranda rights. When they just stop you, they do not, before asking questions that could serve to incriminate you, have to provide you your Miranda rights. Because detention is not custody. Okay? Here's a good idea. Here's a good example. All right? Meet Barry the Badger. Barry the Badger's a dipshit. Okay? Barry the Badger's walking down the street. All right? Here comes Barry walking down the street, and here's the mean old police officer. The mean old police officer, hey, Barry, come on over here. And Barry comes on over there. And the police officer says, hey, Barry, did you burn down a house last night on 5th Street? Yeah. Off to jail Barry goes with apparently the cop riding him, okay? Was his rights violated? No. Number one, was not detained. Detention is a stop, okay? If the police officer goes over and goes, hey, Barry, come here, and pulls him off to the side, that's a detention, all right? A detention is a situation that you are not free to leave from, all right? That, what Barry just did with the cop stopping him, that is a voluntary encounter with the police. You are free to leave at any time. You are not in a situation where you can't leave. And even in detention, you're not in a situation where you can't leave. It's when you are taken into custody. And custody has a very special meaning. Custody means when you are not only not free to leave, but it is clear they are not going to let you go. Custody is a circumstantial decision. It is such that you are not only in a location where you are not free to leave, but you are also in the control of the authorities. That's a very simplified way of doing it, but that's the best way to describe the legal determination of when somebody is or is not in custody. Now, does that in and of itself mean that they have to give you your Miranda rights? Absolutely not. They can take you into custody, never ask you a single question. They don't have to give you those rights at that point. They don't. Why? Because the Miranda rights are intended to protect your interests. They are intended to tell you what, once you're in custody, what rights you do and don't have vis-a-vis interrogation by the police, so as to preserve your Fifth Amendment rights. Your Fifth Amendment rights not to incriminate yourself, and your Sixth Amendment rights. Your Sixth Amendment right to have an attorney present and representing you in all criminal matters. Okay? So, you're in custody, and they're not asking you questions. Do they have to give you your Miranda rights? I'm looking to the chat again. You're in custody. They take you in. You're sitting in the police station. Nobody said a word to you. Nobody's asked you a question. Nobody said a word to you. Do they have to give you your Miranda rights at that point? Keeping in mind that the purpose of the Miranda rights are to avail you of your Fifth Amendment right against self-incrimination and your Sixth Amendment right to have counsel present at all stages during a trial or prosecution for a criminal offense. Do they have to, putting you in handcuffs, taking you into the station, give you your Miranda rights without anything more? Looking to the chat, I want to see your answers, guys. Folks, I'm getting myself away. While I'm waiting for your answers, I'm getting myself away from guys. I'm moving myself to folks. I feel it's much more inclusive. Spontaneous confessions. Nope. You're all absolutely right. They do not have to. They do not have to give you your Miranda rights at that point. Now, let's say the officer walks over and says, hey, what's your name? All right. And you give him your name. and he runs your information, and he finds out you have warrants out for your arrest in 15 states. Did he have to give you your Miranda rights? Can I, as your attorney, bring a motion to suppress because he asked you a question that tended to incriminate you? You told him your name, which then led to the warrants. Can I bring a motion to suppress all that warrant information, which is a motion saying they exceeded the scope of their authority under the constitutional amendments that apply to that authority, so that evidence should get thrown out? Can they ask you your name if it would tend to incriminate you without giving you Miranda rights? What they demand your ID? Dozer says no. I assume that they did not have to Mirandize you. Generally, Daniel, once you're in custody, you got to identify yourself. There's a difference between, I know what you're getting at, Daniel. What you're getting at is making it an offense for you not to provide your ID and identify yourself to a police officer in and of itself. Generally, once you're in custody, they can determine your identity. One quick aside before I get on with this. Because somebody just said in the chat, you must provide identification. That's not always true. There's actually a large amount of litigation over whether or not the police can demand that you provide identification when you're not suspected of any crime or any other activity. There's a huge amount of litigation about whether or not you have a positive duty to identify yourself to a police officer. But the people who are saying that, no, you can't get that evidence thrown out just because they asked the name is correct. There's certain things like identification thing that the police are allowed to ask that generally and reasonably would not tend to incriminate somebody. And that brings up a point. Okay. When you are given Miranda rights, when you're given those rights, it is in a situation where the police are reasonably believing that those answers may tend to implicate your Fifth and Sixth Amendment rights. For the vast majority of people, asking your name is not going to incriminate you. Therefore, the courts have said, reasonably, the police could not have believed that it was necessary to give Miranda rights before asking for a name. A name doesn't tend to incriminate somebody normally. So we're not going to require them. And that's a way that the police do get around Miranda rights, is they say, we asked a question that we asked him if he wanted lunch. He was in an interrogation room. The detective was going to interrogate him and give him Miranda before that. I will open the door, looked at him, and said, hey, do you want a Sprite or something while you're waiting? He said, I didn't mean to bash your head in, man. That's not a Mirandize. That is what we call a spontaneous utterance. It is a response to a question that is being asked, but not the question that is being asked, or a statement by a criminal defendant made prior to Miranda that was not sought by the police. So the Miranda rights apply not when they take you into custody and not when they ask you any questions, but when you are in custody in a custodial setting. You are not free to leave, and they are interrogating you. They are asking questions that reasonably could be believed to lead to answers that would implicate your Fifth Amendment right against self-incrimination. All right? So if they were to say, did you kill them? And you said yes, and they had not Mirandized you, they had not provided you with the summary of the Miranda rights, that could be suppressed. And I say could be because it's always an analysis. But that could be suppressed. But if they say, do you want a Sprite? And you say, I didn't mean to bash your head in, that will not be suppressed. That is a spontaneous utterance and is not an answer to a question that was reasonably designed to elicit self-incriminating information. So you can see where we have all these layers, and I'm going to add one more. I'm going to add another layer. Anything you say can and will be used against you in a court of law. That is the part of the Miranda rights drawn from the Fifth Amendment, and we all know it. We've all seen Law and Order at some point in time. By the way, if you want to revitalize the justice system, maybe start holding up public defenders the way we hold up prosecutors in the current media, because I don't know about you, I've never seen Dick Wolf do Law and Order Public Defender's Office. They're amazingly underfunded, and they do really good work. Anyhow, to keep going through this, they say that and you decide you are going to exercise your right to remain silent. You are going to, and they say anything you can't say can and will be used against you in a court of law. You don't say anything. You don't say a word. They just keep asking questions. You sit mute. You remain silent. Can they introduce the fact that you refuse to answer those questions in court as evidence of guilt? As evidence that implies you were refusing to answer because you were guilty? Can they do that if they then charge you? Hayde, you are talking about the National Legal Aid and Defense Association, NLADA. By the way, while we're talking about this, while we're talking about donations, I've been told that somewhere in that general area is a link to IRPS, which is the Indy FurCon charity. Obviously, the charities that tend to receive money from the furries have been hurting this year. They've been hurting because there's been no cons. So if you have it in your heart and your pocketbook during this time of need, please feel free to go right, I believe, up there. I think they said it's upper right corner. If not, I'm pointing at the X bar. Please don't click on the closed window. And give some money out to IRPS. Daniel says, no, because you are innocent and until proven guilty. Incorrect. As a couple other people have noted, you have to specifically assert your right to remain silent. It's an oxymoron in a way. In order to remain silent, you must speak. All right. Otherwise, if you just stay quiet, of course they can use it. If you say to them, though, I am invoking my Fifth Amendment right. I am invoking my right to remain silent. And by the way, don't change that wording. I am invoking my right to remain silent. Then you shut the hell up. You shut the hell up after that statement. You have to positively take it. Otherwise, they certainly can talk about your silence in court. But if you invoke your First Amendment right, if you clearly invoke it, they can't talk about the fact that you invoked your rights because you are entitled to take those rights. Once again, the law is weird. Let's talk about your right to counsel. There is a case out there. It's called the lawyer dog case. If you have seen me do this panel before, you are aware of my feelings on the lawyer dog case. The gist of this, if you were in an interrogation, okay, and when we stated that you have to affirmatively assert your rights under Miranda. So you're in an interrogation, you're being interrogated by the police. The police say, they ask you a question and you say, maybe I want a lawyer here. Now, once you assert your right to counsel with the police, they stop questioning you. They're done. They can ask you things like, hey, do you want a soda? Hey, there's this, what's your lawyer's name or something like that. But they can't ask you interrogative questions anymore without you waiving that. Okay? So you say, maybe I want a lawyer here. And the officer then says, yeah, maybe you do. So did you kill her? And you say, yeah. Can I suppress that, saying that you asked for an attorney and they continued to question you out of that? After that, did they violate your rights at that point? You said, maybe I want a lawyer, and they continued to question you after that point. Have they violated your rights? Once again, look into the chat on this one. I'm vaping because I'm not in a hotel. We're in my basement and I get to vape. There we go. Head Foxen hit the nail on the head. You have not asked for an attorney. You have suggested you may want an attorney. Courts have allowed the police to say they did not affirmatively and clearly ask for an attorney. They suggested they may want one. It has to be a clear and unequivocal assertion of your right. Okay? The case that brought this up is recently, you may have seen the notice, I said recently, but it was like 3 years ago. A gentleman, a horrible gentleman, by the way, was arrested in Louisiana. And he said to the police, if you all think I did it, I didn't do it, you might as well get me a lawyer, dog. And they continued to question him after that point. And they moved to throw it out. And the court said, no, we're not going to throw it out. And the appellate court in Louisiana looked at it and said, yeah, we're going to affirm this. We're going to say that the court was right in not throwing it out. So when they did that, everybody lost their shit. And they lost their shit because there was one appellate judge who wrote in his opinion. By the way, it was a per curiam opinion. Per curiam meaning, by and large, that they didn't really have discussion on it. Everybody was in agreement. They could have just said affirm per curiam and signed the order. But one jackass judge decided that he was going to write an opinion on it. And in his opinion, he said, well, it wasn't clear. The suspect could have been asking for a canine attorney. He, because that's what we fucking do when people's freedoms are on the line. If we're fucking judges in Louisiana, apparently we the Sixth fucking Amendment. Anyways, the thing is they reached what in the current state of law is a correct decision, but for the wrong reason. It's not, in my opinion, the correct decision, but my opinion doesn't matter unless they change the law. You see, while the internet lost its shit about the part that was lawyer dog, it's the colloquials, attorneys looked at the order and they said, well, the judge is an asshole, but under the current state of law, the judge is correct. Because the stress wasn't on, I want a lawyer dog. It was, if you think I did it, you should get me a lawyer. If you think I did it, that is a conditional statement. And that's the one the police relied on to deny him the right to an attorney prior to continuing interrogation in that matter. If you think I did it. If you don't think I did it, I don't want a lawyer. If you think I did it, I want a lawyer. And the court said that is a conditional statement. That is not a clear and unequivocal assertion of your rights. Therefore, they were allowed to continue interrogating you without an attorney. Personally, I think that's bullshit. People who are innocent and speaking with the police, and the police are like, we don't suspect you, and they believe the police, may think they don't need a lawyer. They may say, look, if I'm a suspect, I want a fucking lawyer, man. I think that's completely reasonable. But the courts have evolved to do that, which is leading to another thing. The law does not exist to serve, at least in criminal matters, you. It doesn't exist to serve you. It exists to some degree to protect you. When we interpret these statutes, we remove a lot of those protections in favor of it. If you ask me as an attorney and as somebody who does do criminal work, I believe the phrase, if you're asking me if I did it, I want my lawyer, should be a full, fair, and unequivocal assertion of the Sixth Amendment. But that is why I will tell clients, and I will tell you, a secret phrase. When the police are interrogating you about anything, if the police say, hey, I got some questions, come on down to the station. We don't think you did anything. We just talk. One, don't go. Make them arrest you. Do not voluntarily put yourself into an interaction with the police in that situation. Okay? You waive so many rights when you voluntarily interact with the police. I'm not sitting here like, all police are assholes, no matter what I think. I'm just telling you, you waive so many rights by voluntarily interacting with the police in these situations. If the police call you and you're not the victim, then ignore them. They'll come by. They can ask the question you all you want, and your response should be as follows. I am asserting my right to remain silent, and I will not speak to you without my attorney present. And close the fucking door. Make them arrest you. You have more rights once the police have, against your will, placed you into custody than you will ever have by voluntarily submitting yourself. Now, this is not to say fight the fuck out of the cop. If you get stopped for speeding, do not lean out the window and deck the patrol officer to make them arrest you. Don't do that. What I'm saying is, if they, don't walk up to the officer and say, "Yeah, let's go back to the station and talk a little bit, officer." You have more rights once you are arrested than you do through an independent submission to that. Okay. A traffic stop is not a voluntary interaction. A traffic stop is actually a detention for the investigation of a crime. However, that does bring up one more thing, and this always happens. I start talking about criminal law, and we end up on this. And I'm like, one more thing, and then we'll get to this stuff that will actually affect you. But I end up talking about the sexy shit. I really need to start making a PowerPoint for these things. Let's say that you are stopped by a police officer, and the officer says, "Do you have any drugs in the car?" You say no. And he says, "Okay, I'm going to call K9. And the K9 unit takes an hour to get there. But when they get there, they find drugs. At no point during this has the officer written you a ticket. Can the drugs from the K9 unit be suppressed at trial? I'm watching the chat for the answer on this one. The fact pattern is as follows. You're stopped, let's say for speeding. You're stopped for speeding. The officer takes down your information, says he's going to call a K9 unit to search your vehicle. The K9 unit takes an hour to get there. It locates on a part of your vehicle. They search the vehicle based on the locate. They find drugs. You are arrested. Can that be suppressed at trial? Yes or no? I'll give you about 30 seconds, and then I'm going to answer. No warrant for the search. Warrant's not needed in that situation, Daniel. Believe it or not. Silver says no. The answer is yes, actually. The answer is yes on this one. Why? It took an hour. Courts have consistently held that a traffic stop cannot be extended longer than necessary to issue a ticket for the infraction committed. Okay? If a speeding ticket takes 20 minutes for them to run your plates, walk back up, issue the citation, get in the car, and leave. Courts have consistently held that without something more, without in those 20 minutes you saying or doing something that creates that, they cannot detain you longer than is necessary to complete that. And it's actually a rule that kind of evolved from Terry v. Ohio, which is we have, they're called Terry frisks, Terry searches. Okay. A Terry search, a Terry frisk, a Terry stop is an investigative stop to determine what a temporary detainer in an investigatory stop made to determine whether, on reasonable suspicion, whether or not a crime has been committed or is in the process of being committed. It comes from a case called Terry v. Ohio, where a police officer saw a guy casing a bank. The guy was walking back and forth in front of a bank, and the police officer went over and said, "Hey, buddy, come here," and detained him, patted him down, and found a gun in his pocket. They arrested him. Turned out he was going to rob a bank. He moved to suppress. The court said, "No, after watching you, he was able to state a reasonable suspicion for stopping you temporarily to determine whether or not you were committing a crime." That doesn't mean they can stop anybody. It means they have to have reasonable suspicion to stop that person. But the rule with Terry is they can only hold you for so long as necessary to confirm or deny the suspicion. And that goes back to this traffic stop we just talked about, the K9 officer. They cannot keep you on the roadside longer than would be necessary to fulfill the reason for the initial detention. The initial detention, in this case, being justified by the speeding ticket. If it takes 20 minutes to issue a speeding ticket, they got 20 fucking minutes. Okay? They got 20. And that's why I say, if they say, "Are there any drugs in the car?" Nope. Or, even very simply, Are there any drugs in the car? Could you please just issue me the ticket? Now, things like that. The way they get around this, okay? Say the officer issues you the ticket, okay? You're within in 10 minutes. He pulls you over, gets your license, gets your registration, walks back to the car, runs your tags, comes back up to the car, hands you the ticket, says, okay, have a nice day. He turns, he takes 2 steps away, turns around and goes, oh, hey, I got to ask, you don't have any drugs in the car, do you? And you say, well, no, of course not, while being all shifty-eyed. They says, you know what? I'm going to call a K9 unit. Hang on. K9 unit comes, points on the drugs in the car. They find the drugs based on that search. They arrest you. You go to jail. You go to trial. Can I move to suppress at trial under those circumstances? The officer gave you the ticket, walked away, took 2 steps away, turned and said, hey, I got to ask, do you have any drugs in the car? Can I suppress the drugs at trial under that situation? Still, everything else is the same. Still takes an hour for the K9 unit to get there. Everything else. Can I suppress? I'm looking to the chat. I see a lot of answers, and a lot of them are right in that they're saying no. But I'm going to go with one of them. The stop hasn't ended until you've departed voluntarily. Wrong. The stop was over the moment they handed you the ticket and started to walk away. The moment they handed you the ticket and started to walk away, the traffic stop was over. Multiple courts have held in this manner. When he turned around and said, hey, I got to ask, do you have any drugs in the car? Courts have ruled, several courts have found, that was the beginning of a new encounter. The reason for the stop had ended, the stop had completely included. The officer turned around and at that point tried to engage you in a new voluntary encounter. And when you answered his question, you conceded to that voluntary counter. You agreed to it. At that point, it was a new stop. And now they can use anything you say. Somebody said you don't have to answer. I think the answer to that, hey, one more thing. Do you have any drugs in the car? I'm not gonna, are we done? One more thing. Do you have any drugs in the car? I've got the ticket. Can I leave now? It's not that they're going to say yes, they may not. But you want to have them on record on that video that every cop car has sitting on a dash cam recording the moment they flick their lights. You want to have them on video with you asking, hey, you've given me the ticket. Can I leave? And have them say, not until you answer my question, or something like that that makes it very clear that you were not free to leave, you were being detained, and that they should not have proceeded at that point. That's how we do it, which brings me, I didn't get to civil today, and I hate it when we get civil, which brings me to one of the bigger things that I have to make really, really clear. And I think it's very important to say that right now, in the way that our country is handling things. I try not to get too specific, or too political, but I want to be very clear. It doesn't matter what legal defense you have if you're dead. Any lawyer worth their salt can argue they shouldn't have made a stop, can argue they exceeded their authority, can argue so many things if they do exceed their authority. And what I am giving you now, what I'm telling you, hey, I have my ticket, can I leave? Hey, I'm not going to come in and talk to you without my lawyer. Hey, I'm not going to talk to you, period. Hey, I'm going to close my door. All those are ways that you can signal to the police without screaming it at them. I know what my rights are in this regard. I know I have them. You know I have them. And by the way, they know they have them. They know that you have these rights. Believe it or not, I have seen prosecutor training manuals for the police where they detail new constitutional cases and then say, but if they do this, it's fine. They're aware. The police are trained in this. But at the end of the day, if the police decide they're going to arrest you, they're going to arrest you. And no amount of yelling or screaming or saying, I have my rights, or struggling is going to get you out of that situation. And in that situation, it is best to not die. If they violate your rights, any attorney worth their salt can help. But we can't help a dead person. Somebody in the chat said, if they say yes, but I'd like you to answer the question, and you don't leave, you are voluntarily interacting. No, you just say, I'm not going to answer the question. You know, am I free to leave? Are we done? Yeah, but I'd like you to answer the question. I'm not going to. Bye. Make them chase you at that point. I mean, I'm not telling you run from the police, but I'm saying, well, if we're done, I don't have to answer the question. I do not consent to any further interaction, officer. If we're done, I'm leaving. It's just that simple. The fetishization of law enforcement and authority is problematic for criminal attorneys because we are taught from a very early age that if a police officer asks you something, they're asking it to help you, and they're not. As a matter of fact, one last point in the last 5 minutes that I want to bring up that many people are aware of, but not many people talk about, is the police are allowed to lie to you. They can lie to you. They can walk in and just absolutely lie to you. They can put you down and say, look, ma'am, we know that you were at her house last night. We know. We've got 3 witnesses said they saw your car out front. You know, we know. And you say, maybe you say, well, no, I wasn't at her house last night, but I was at her house this morning. I was at her house the day before. They may not even know if you even know the fucking person that they're talking about. They may not even know if you know the victim. But now, in what they've cooked up, they've lied to you. They don't have a fucking witness. They got nobody who says that. They're telling you that to get a response out of you that supports their theory of events. What if their theory of events is that you knew them, therefore you wanted to kill them, and now you've not only confirmed that you knew them, but that you know where they live, and that you had been there in the last 72 hours. All from one lie. All from one lie. The police are allowed to mislead you. They were allowed to say, look, man, we're going to get you out of this. It's me and you. I believe it. You're a nice guy. Those are interrogation techniques. They are allowed to lie to you to get answers from you. And one last thing, going back to Miranda. And this is one of those where the courts did come down correctly. A gentleman had been arrested. There was a shooting. The gentleman had been arrested. He was a suspect. They Mirandized him. He said he wanted to remain silent. They had him in the back of the vehicle. They're transporting him to the police station. As they're going to the police station, they knew this man had nieces, nephews, and children. They began to say, man, there's a lot of kids in the, to each other, not even talking to him, to each other said, there's a lot of kids in this neighborhood. It'd be a shame if one of them found that gun and got it and shot another child. It'd be horrible. It'd be horrible. They knew the guy in the back seat had kids. They knew he was a father. They knew he was an uncle. They also believed that he was a murder suspect and that he had dumped the gun. And he had asserted his right, so they couldn't ask him. So they began talking within his hearing amongst themselves to prey on his sensibilities and to prey on his particular mindset by saying if a kid found the murder weapon, they could really hurt someone. And the guy said, "Oh, geez, I don't want kids to get hurt. I'm going to show you where the gun is." And they drove him out there. They got the gun. They arrested him. They charged him. His lawyer came in and said, "Hey, we know they weren't asking him the questions directly, but they were having this conversation directly in front of him, knowing his background. And it was a clear attempt to elicit an incriminating response by getting him to tell them where the gun was and showing he had the knowledge." The courts agreed and said that your rights, when in the custody of the police, extend not only to custodial interrogation, where they're directly asking you a question, but anything intended to elicit a response. I tell that because a lot of this so far was doom and gloom, and you're going to sacrifice your rights and they're going to fuck you. That's not the truth. The truth is, the reason we have a criminal justice system, the reason we have people, lawyers and people like me and judges out there, is to try to protect you a lot of the times. And sometimes we fuck it up sometimes, but sometimes we get it right. Once again, I did Nothing But Criminal. We're at the 3 o'clock mark. Folks, thank you so much for joining me. I am Boozy. Boozy Badger. I hope to see you again next year. I'll be back actually in like 2 minutes with Iggy's stuff. Then this evening with Comedy Better, then another Iggy thing. Then tomorrow at 5 o'clock, we've got lawyer horror stories where I'll be joined by a bunch of lawyers as we take questions from the chat and tell you rambling stories. Please donate to ERPS, and I'm going to get the heck out of here so the next time I can come on. Rabbit!
Silver Gato Man, he bought me a coffee. Silver Gato Man, here is the song for thee. He likes to video all the panels at the cons. You should go and watch them whether they are short or long. Silver Gato Man, you video that's not a jibe. All of you go to his YouTube channel and like and subscribe.